Hello, I'm Matthew Gavidia. Today on the MGH Life Sciences News Network, the Center for Biosimilars is pleased to welcome Nicholas K. Mitrokostas, an intellectual property law attorney with Goodwin Proctor, Boston, and editor-in-chief of BigMoleculeWatch.com. We haven't gotten interchangeable biosimilar designation from the FDA yet, but some states are allowing interchangeability, and some hospitals and healthcare systems have reworked their pharmacy protocols to allow automatic substitution. Can you discuss this and touch on whether the FDA has fallen behind the curve on this one?
Well, I think what we're seeing is that the interchangeability designation is still sort of a prize, so to speak, for biosimilars manufacturers because it requires not only that you demonstrate your product is highly similar to the reference product, but also that it's going to provide the same clinical result, and that switching between the reference product and the interchangeable product is not going to lead to any greater risk of adverse events or any differences in safety and efficacy. So it requires additional studies, but of course it leads to significant rewards, which is that the automatic substitution can happen at the pharmacy level by operation of state law. Now, you mentioned that some states are getting sort of ahead of FDA and saying, we're going to allow substitution for some products. And I think what really is going to be the issue here is how doctors prescribe the products and what they choose to do. The biosimilar action plan that Scott Gottlieb FDA released in a couple years ago really focused on sort of how to educate clinicians about biosimilar products and the fact that they have been approved by FDA to be highly similar to the reference product, and therefore, presumably, obviously, can be used in the approved indication for the reference product. But really, whether or not those products get used is going to come down to how doctors operate in practice. Now, the interchangeable designation sort of bypasses the doctor practice in the sense that the doctor, will write the brand or reference product name, and then the pharmacy will just substitute it. I think that we still will see, and I suspect we will have a number of biosimilar manufacturers try to seek this interchangeability designation because of the real value of that automatic substitution that comes from FDA saying, additional studies have been done, and these studies demonstrate that there's no increased risk from switching between the products. Now, the second part of your question was, has FDA fallen behind? I think FDA is trying to really sort of facilitate the development of interchangeable products. I think that's clear from the guidance they put out last May 2019, with respect to interchangeability, where they made clear that they're looking and they're encouraging manufacturers of biosimilar products to really take a stepwise approach in the development of an interchangeable, and sort of evaluate in each stage of the development process, is there uncertainty about whether this product can be interchangeable with a reference product? And if so, how can I demonstrate that, that it is interchangeable and sort of address any uncertainty? They also made clear that, structural and functional complexity will influence how difficult it'll be for a manufacturer to get that interchangeability designation. So something that has, let's say, one target and has low complexity, is an example FDA gives, may be easier to be demonstrated as an interchangeable than a product that has high complexity and maybe has multiple indications and multiple targets in the body. That might require more studies and more work to demonstrate interchangeability. And this guidance really lays out for developers of biosimilar interchangeable products how to go about doing that. I mean, the other thing, a key piece from this FDA guidance is really in the switching study aspect. there, FDA indicated that switching studies sort of obviously are going to be required for demonstrating that you can switch between the two products, but it gave a lot of guidance onto how the studies should be conducted in order to meet FDA's requirements. And I think developers of biosimilar products seeking an interchangeable designation now at least have sort of a map, I would say, a roadmap to how to put together their development program in order to sort of ensure timely and successful approval of their interchangeable product.
Can you describe the value of immunogenicity studies for biosimilars and insulins and tell us whether the latest FDA guidance makes it more or less likely that immunogenicity studies will be required?
Sure. So just to take a step back for a minute, immunogenicity is just for those who are not as familiar with the concept, is basically just the potential for a therapeutic protein to cause an immune response in the human body. And one of the key attributes of therapeutic proteins, like the ones that are approved as biologics and biosimilars, is they have a high potential to lead to immunogenicity. And so typically, immunogenicity is one of the main criteria that are evaluated in both the approval of a biologic and a biosimilar to ensure that the therapeutic protein or therapeutic molecule is not going to induce this immune response in the patient that could lead to serious adverse consequences. Now, with respect to insulin, FDA put out a guidance late last year indicating that while insulin previously had been believed to have sort of concerns with respect to immunogenicity, recent studies, experience with insulin products over the last several decades that have been on the market have indicated that immunogenicity was less of a concern than originally anticipated. And therefore, what FDA was indicating to developers of insulin products is that, that the highly similar sort of prong is really going to be the key attribute in leading to approval of a biosimilar. Not that there's not a concern for immunogenicity, and that a immunogenicity test or a comparative clinical immunogenicity test may still be required in certain instances. The FDA said that it's likely unnecessary for insulin products, given all of the scientific evidence that has come to light with the use of insulin products. And so developers of insulin products with this guidance in hand, should obviously, seek out FDA's views as they're working through their file and their development program to determine whether in their case, an immunogenicity study would be required. But it seems from all indications that FDA has given in this guidance that more often than not, a developer of an insulin product will likely not be required to do the comparative clinical immunogenicity study.
With respect to labeling and advertising, the FDA and FTC have said they want to prevent anti-competitive messaging, but do they have the tools they need to stop this?
That's a really good question. So I think there's sort of multiple considerations here. One is FDA has been taking action in the sense of it's been putting out guidance on labeling and promotional materials for biologics and biosimilars, with this goal in mind, in my view. So earlier this year, they've released a draft guidance on sort of in the form of a Q&A that gives developers of both biologics and biosimilars some sort of examples of what would be misleading in the context of promotion and labeling for bioproducts. And I think that's sort of one tool that FDA has. But clearly, they don't really have, more of an arsenal as maybe some of the other government agencies, but they can obviously take action if someone is engaging in misleading and inappropriate labeling and promotional materials. So developers would be sort of wise to look at the guidance and think about when they're putting their label together and their promotional materials, what is going to be sort of not seen as misleading. So, for example, the guidance talks about otherwise true information, like let's say data from a clinical study that may be true in the sense that it's accurate, it's representing the clinical study, but it can be presented in a way that's misleading if it gives, for example, the impression that a biosimilar product is more or less safe than a reference product, right? Or another example that's in this guidance is when a biosimilar product is approved for fewer than all of the approved uses for the reference product, would it be misleading to have a side-by-side column where you have the reference product is approved for 10 uses, but the biosimilar is only approved for 1 or 2? While that is, truthful information, it can lead to the impression that one product is more safe than or more efficacious than another. And so, the guidance really does lay out a lot of concrete examples for developers. And I suspect that, to the extent companies don't follow this guidance and do sort of engage in misleading labeling and promotional materials, that we will see action. We'll see action from FDA. We'll potentially even see action from FTC. I think the issue is going to be the second sort of consideration here is sort of how receptive will courts, for example, be to claims made by third parties or government agencies with respect to labeling and promotional materials leading to misleading information.
And lastly, what does it mean if the FDA approves a biosimilar for fewer indications than the reference product?
Well, essentially, FDA has also put out guidance on this over the last year and said that a biosimilar applicant may seek approval for fewer than all of the indications. In the case of an interchangeable product, FDA said its preference would be for the applicant to seek approval for all of the approved indications for the reference product, but nothing precludes an applicant from seeking approval for just one of the approved indications. And what that essentially means is that, for a particular molecule, biosimilar can be used for that approved use. Now, obviously, doctors, it really comes down to doctors' prescribing preferences. So doctors then decide, I've got this reference product that's approved. I've got, these 3 biosimilars that are approved for the same sort of indicated use, and they can choose which one they want to use. There's obviously, like, doctors have freedom to prescribe products even off-label. At least in the small molecule context, we've seen that doctors have done that in some instances. They have approved products for they have used products for uses that were not approved, so long as there was obviously a clinical basis for the doctor to believe that they could use the product in that way. I suspect that in this space as well, we'll see how it plays out in the market.
To learn more, visit our website at centerforbiosimilars.com. I'm Matthew Gavidia. Thanks for joining us.